If someone is not released, they're brought to court for a bail hearing. This takes time. The accused will be brought in the morning, then Crown Counsel will be alerted as to their presence and the file will be put together. The Crown will look at it and they'll decide whether they want to detain the individual or they're prepared to release them. If they're prepared to release them, they'll suggest conditions, and that's called a consent release. They write out the conditions. The conditions are given to the accused. If the accused agrees to be released on those conditions, they sign off on it and they're released. Generally speaking, duty counsel will be there to assist. Duty counsel will arrive in the morning, interview all the people in custody, then contact the Crown, find out who the Crown's going to consent release and which ones require a bail hearing. Of course, if the accused has their own lawyer, that lawyer could be part of that process. If they're consent released, they're bound by the conditions on that consent unless they are later modified. So people should be careful about the kinds of conditions they're put on. If they are not consent released, then it's a bail hearing. Again, if it's a first offense situation, the Crown must prove that there's a substantial likelihood of another offense occurring, or the person is not likely to show up in court. But on a breach, the onus shifts to the accused, where the accused has to show why they should be released. Now, it could be they are simply released on their promise to show up on another court day. It could be there's a dollar amount attached to it. That's not a cash bail, but it's a promise to the court that they'll show up and abide by the conditions, and in the event they do not abide by the conditions or don't show up to court, the Crown can go after them for that dollar amount. The next step up, however, is a surety bail or a cash bail, where the Crown is prepared to release the individual, but they want someone to sign, someone to, in effect, be their jailer, a relative, a friend, someone who has the means to pay, if they have to, a certain amount. But they promise to watch after the accused, make sure that the person gets to court and doesn't reoffend. There's usually a dollar amount attached to that. That's called a surety, and say, as an example, $1,000 with one or more sureties. That means there's no money put up, but the surety is saying, I'm going to look after this person, I'm going to watch this person, and if something goes wrong, I'm prepared to pay the $1,000. Now that seldom happens, but it's a risk that a surety takes. The way around that is that a surety can render an accused. So if you have decided that you're going to be a surety, but you're not satisfied with the performance of the person in the community, all you have to do is phone the police, say, I'm the surety, I want to render this individual, I don't want to be a surety anymore. That protects you from having to pay the money that's attached to being the surety, and the accused is arrested and they won't be released until they find another surety or other conditions are put upon them. It could be that there is a cash bail, whereby somebody has to put actual money up in order to have an accused released. If that's the case, and you happen to be the one lending the money, then you will want to get an assignment of that bail money so that you get it back, assuming the person doesn't breach his conditions and shows up in court. The other possibility, of course, is the person simply detained. And if they're detained, they have a right to have a review in the Supreme Court, but in a general sense, they're stuck in custody until such time as the matter is dealt with, either by trial or by a guilty plea.